Welcome back to the D4U USA channel. If this is your first time joining us, welcome! We are immigration experts helping entrepreneurs and professionals live their American dream through their business, their investment, and their profession. I'm attorney Mari Ribeiro, a lawyer licensed in Florida, and today we're going to be talking about the EB2 application, either as an adjustment of status or applying by consular processing, and how to know which one is the best option for you. Now, before we get started, while yes, I am an attorney, it's important that you understand I am not your attorney unless we have an agreement that says otherwise. So everything we're going to be talking about today is not to be considered as legal advice. It is only going to be for educational purposes only. So let's dive in. Let's do a recap. What is the EB2 NIW? Well, this is a visa based on your profession that gives you the right to live and work in the United States. Now, what does the NIW stand for? It stands for National Interest Waiver, meaning that having you here in the United States actually benefits the entire nation, and the government will waive the requirement that you have to have a job offer from a U.S. company sponsoring your petition. So you don't need a sponsor for your immigration application because the work that you do is so valuable to the entire country. This is what makes the EB2 NIW so attractive, because you can self-sponsor your own immigration application and you don't have to rely on a company to petition for you. So when you're ready to apply for your EB2 National Interest Waiver, there are two ways that you can submit your application. You can either apply for your EB2 National Interest Waiver through what's called the consular process or through an adjustment of status. Most people may think that there's a difference in how your application is evaluated, like perhaps you have a better chance of approval if you submit your application one way or the other. And this is not the case at all. There are some differences in applying for the EB2 National Interest Waiver through the consular process or through the adjustment of status, and that's where I'd like to start with our consular process first and telling you what those differences are. The consular process is when you are applying for the EB2 National Interest Waiver from outside of the United States, meaning you will be in your home country during the application process until your application is granted to give you permission to enter into the United States. Another big misconception is that if you apply through the consular process, your application will be reviewed by those who work at the consulate office in your home country. This is also not the case. If you apply through consular processing, your application is reviewed inside of the United States by U.S. immigration officers the same way that all other applications are reviewed. All EB2 National Interest Waiver applications are either reviewed in the office located in Texas or in the state of Nebraska, regardless of whether you do the consular processing or not. Another myth is that one office is known for approving more applications than the other, or that one office processes applications faster. Neither one of these are true. So once you submit your application through the consular process to the U.S. Immigration Office, it will be reviewed, and before it is approved, you will be asked to go to an interview, and this is where the consular process is a bit different. So your interview will be held at the consulate in your home country by an officer working at the consulate. Now, notice that I said in your home country, and I do mean the country where you live. So for example, if you are a Portuguese citizen, you don't have to go to the consular process in Portugal. You could be living in Spain, for example, which is your current home country and where you would do the consular processing. So the consular process gives you freedom to apply in any consulate in any country that you live, regardless of your citizenship. So, what's the benefit of applying for the consular process for your EB2 national interest waiver? Firstly, you don't have to stop living your life while you wait for your application to be approved. You can continue living in your home country and getting yourself organized to make your move to the United States. You'll still be able to work, make money, and support yourself and your family while you wait for the application to be approved. And you can also travel in and out of your home country while you wait. So this is a great option if you want very little disruption to your daily life while you are waiting for your EB2 national interest waiver to be approved. Now let's talk about the adjustment of status. The biggest difference in applying for the EB2 as an adjustment of status is that you are applying while you are already inside of the United States. So for example, you come to the United States on another visa, let's say the tourist visa, and while you were here, you decided to apply for the EB2 national interest waiver so that you could stay in the United States. You would be adjusting your status from a tourist visa to the EB2 national interest waiver. Now, it's very important to know that when you enter the United States on any other visa, you cannot adjust your status for at least 90 days. So you will have to wait inside of the United States for 90 days before you can submit an application to adjust your status. So there is a restriction that you have to consider if you are going to be doing the adjustment of status for your EB2 national interest waiver. As part of your adjustment of status, you are usually going to be applying not just for your EB2 national interest waiver, but also you're likely to apply for your travel document so that you can travel in and out of the United States. And also your work authorization so that you can work in the US once your application is approved. Now, the adjustment of status does have other restrictions that you should know about. While you are waiting in the United States for your adjustment of status to be approved and your work authorization to be granted, you will not be able to work until you actually receive your approval. This means that you must have a plan for how you will financially sustain yourself while you wait for your work authorization. Similarly, if you are applying for your travel authorization with your adjustment of status, you will also have to stay in the United States and not leave the country until you receive your travel authorization. This is super important to know because you will not be able to travel to your home country or any other country during this waiting period. And if you do leave, you are essentially abandoning your adjustment of status. So as you can see, there are major differences in applying for your EB2 national interest waiver through the adjustment of status or the consular processing. And the best way for your application to be submitted is really going to depend on how you prefer to wait while your application is being reviewed and approved. If you prefer to continue living and working in your home country while you wait for your EB2 to be approved, then the consular processing will allow you to do just that. On the other hand, if you'd like to apply for your EB2 while you are already in the United States and stay in the United States while you wait for your approval, then the adjustment of status, it would be the best option. As always, I hope you found this information helpful on your journey to immigrating to the United States. And if you need more help, of course, I am leaving our email here so that you can contact D4U USA, and I'm looking forward to seeing you on the next video.